for effective public participation, which has not happened at all. An effective public participation process should therefore provide for stages of participation that are commensurate with the level of public interest. And the public interest in relation to cannabis is immense. This group has seen that the hearing that we had on the first public hearings was the biggest that the portfolio committee had ever seen. So there is immense interest on the part of people. There needs to be consultation. They need consultation. The public must be involved. They must be informed. Parliament dismally failed in their duty to ensure that the provisions of this bill was workshopped with South Africans. And despite the fact that the CDCSA and other civil society members sought interaction with government, we were given the cold shoulder. 19 months passed before COVID hit our shores. And in that 19 months, the legislature did not reach out to the cannabis community even once, which is totally unacceptable. And the fact that public participation requirements were not met is a fatal defect to this bill. We are trying to prevent a situation where the Cannabis for Private Purposes bill, as well as the National Master Plan, are challenged in court. If we even just look at the definition of this bill, cannabis for private purposes, that is, to our mind, a contradiction in terms. We require a single holistic cannabis bill. Could we move to the next slide? The bill in its current form still negatively impacts on people's rights to equality, dignity, freedom, and privacy, in that it still proposed to use the criminal penal code to regulate cannabis. We should not use our society's most extreme sanction, which is arrest, to regulate concerns around cannabis, primarily because the alcohol and the tobacco industry, they do not face the same burden as the cannabis community. And those two communities are exponentially more burdensome to South Africa. So why should members of that community be allowed to freely use their products, but members of the cannabis community run the risk of going to jail if they do the same things? The strain on the correctional services and the inordinate costs of arrest and incarceration for the state would be immediately redressed if cannabis were to be descheduled out of the drugs and the medicines act. That doesn't mean that the cannabis community say that there should be no regulation in relation to cannabis. Not at all. We're simply saying that the regulation should not be via the criminal justice penal code. And ladies and gentlemen, it is no coincidence that these public hearings, or the majority of them, are being held in Arbor Week, Boomplantingsweek. And this really exposes an inherent contradiction in the government's approach, where in Arbor Week, we are promoting the planting of trees, but the cannabis bill proposed to send people to jail for planting trees. The Cannabis for Private Purposes bill wants to count the amount of trees that people want to plant, whereas in Arbor Week, we encourage people to plant trees wherever they can, whenever they can. So currently, what we are seeing is a strong dissonance between the Department of Social Development and Welfare and the stance of the Department of Justices, in the sense that the focus should be on harm reduction as opposed to harm prevention, which historically has proven to be an unrealistic target, and therefore cannabis should be descheduled from the Drugs as well as the Medicines Act. Furthermore, Section 14.2c of our Equality Act, the Promotion of Equality and Prevention of Unfair Discrimination Act, demands that the laws regulating the cannabis community may not unfairly discriminate on the basis of criteria that are not objective and which are not related to the intrinsic nature of the activity concerned. In other words, the cannabis community cannot be discriminated against by laws that are not objective or evidence-based. So currently, there's equality concerns in the manner in which cannabis are treated vis-a-vis alcohol and tobacco. So when it comes to our objectives, we are proposing a single, holistic, unified cannabis bill that would enable cannabis for food, clothes, shelter, medicines, and jobs for struggling South Africans. To develop a multi-billion rand cannabis value chain in South Africa centered around indigenous land race cannabis, in other words, DAGA. Enable the empowerment of small-scale farmers and the development of agro-processing cooperative hubs that meet our developmental agenda. Utilize cannabis to meet our commitment to the UN Sustainable Development and Climate Change goals, as well as our own national development plan. When it comes to industrial cannabis, we suggest that we use what we have to get what we want. And what we have is DAGA. This artificial distinction between cannabis and hemp is one that is not based in fact or science. We should allow small farmers to participate in the industrialization of cannabis, utilizing indigenous drought-tolerant genetics that have been cultivated for hundreds of years. We need to treat cannabis as an agricultural commodity, no longer requiring special permits to be grown, and we need to return the plant to a cash crop status. Now, we solve this impasse that we currently have by simply classifying by end use, not while the plant is in the soil, trying to test THC levels or CBD levels, but we rather classify by end use for commercial purposes and regulate at the point of processing. We need to develop an African definition of industrial cannabis, and we should most definitely move away from the arbitrary 0.3 limit on THC that is currently defined in Europe and North America. And therefore, we need to drive research and development based on indigenous land race genetics and global best practice. And in doing that, we would be respecting and protecting our heritage and the potential of our existing cannabis resource base. Could we use?
Mr. Prince, you have 6 minutes.
Thank you very much. I haven't finished sharing my document yet. If the secretary could just move back to the slides.
Yeah, can you move back to the slides?
Mr. Ramana has just been disconnected. We're trying to reconnect. Amaras, can you quickly, you also have rights to share. Can you quickly share? You can also share the presentation, but I'm trying to locate it as well.
All right. Cannabis for health purposes. We should allow cannabis for primary and preventative health care for all those that seek to benefit from the healing attributes of the plants at a low price points to be available to the majority of our people and open the market. The thinking around medical cannabis must be revisited to accommodate the consequences of the privacy judgment, which in essence did put a spanner in the wheel of the provision that was snuck through on the 6th of November 2016, a day before the Constitutional Court hearing. Now, currently the two-tier pharmaceutical and complementary sections on, there's two tiers, pharmaceutical cannabis and then complementary and indigenous cannabis. We need to establish an enabling cannabis healthcare and wellness regime where only pharmaceutical grade medical cannabis for specific conditions is controlled and administered through SAPRA, and establish an enabling cannabis healthcare and wellness regime for complementary healthcare products for non-specific conditions use that would fall under traditional and natural health regulations with access to cannabis through a doctor's or traditional healer's recommendation, which would entitle a person to become a registered and recognized medical cannabis user. We need to shift the focus away from exporting cannabis towards developing a local market for cannabis health products and motivate for research and development based on efficacy, including indigenous knowledge systems and regional genetics to maximize South Africa's competitive advantage, which can be regulated outside of SAPRA. The Constitutional Court unanimously ruled that the personal use of cannabis is not a criminal offense in private. However, this is limiting in that it only allows for those with access to private land the right to grow cannabis, thereby excluding the vast majority of our people. Therefore, the law needs to accommodate a reasonable trade in recreational cannabis to enable people without access to land, as well as those who cannot or who don't want to grow for themselves, the right to still use cannabis in the privacy of their homes. Therefore, we need to expand the cannabis court ruling based on the right to privacy to include the ability to cultivate, extract, process, manufacture, and sell cannabis products, cannabis-based products for recreational use, along the same lines that alcohol and tobacco are currently being regulated. The state must formalize the existing illicit market, or the so-called black market, and allow it to be taxed. The recreational cannabis market is a massive potential revenue generator for the fiscus, while simultaneously positioning us to get ahead of the substance use concern. Alcohol and tobacco currently, they are multi-billion rand industries, and the harm that is attached to these industries are exponentially higher than any harm that is associated with the cannabis industry. We immediately need to establish guidelines for the South African Police Service to operate under that respect, protect, promote, and advance cannabis users' rights, and immediately stop all arbitrary arrest and police brutality towards marginalized communities that often face the brunt of police dagga operations. When it comes to cannabis economics, that is where the empowerment lies. We need the development of production corridors supported by agro-processing hubs that would support at least 20,000 hectares of production and represent a new social compact between government, private sector, and community ownership. Drive a series of decortication and extraction technologies required to process industrial cannabis supported by different processing lines. Process up to 50,000 tons of fiber and 120,000 tons of herd, employing up to 100 plant workers and 50 support workers per hectare. Farmer income per hectare is difficult to accurately determine as there are many variables depending on region, climatic conditions, seed strain, etc. However, there is much money to be made. Working on average, the income can be postulated at about 175,000 rand per hectare, generating revenues of 350,000 for a small farmer on 2 hectares and net revenue of 3.5 billion per cooperative hub farming 20,000 hectares. With regards to a proposed structure for cannabis in South Africa, the developmental state is central to introducing, modeling, and controlling cannabis production so as to ensure the benefit is carried to the majority of the rural poor. Cannabis is a national asset that should be managed as such, with the formation of a cannabis desk in the office of the presidency that could lead to the formation of a cannabis development agency that is in line with the developmental state objective. We should design and implement of an industrial cannabis rollout strategy to develop the multi-billion rand cannabis value chain and to capacitate hundreds of thousands of small-scale farmers, establishing cannabis agro-processing cooperatives that would grade and purchase cannabis for processing, extraction, manufacture, and distribution. Implementation of a cannabis development agency would be comprised of lead officials from government departments, industry specialists, IKS practitioners, community activists who are familiar with the plant and the potential value change. The cannabis desk will be responsible for coordinating the cannabis master plan for South Africa and liaising with all respective ministries. We need to empower our people by empowering our environment. So the South African constitutional order draws no difference between first, second, and third generation rights. Therefore, environmental rights are no less important than civil, political, or socio-economic rights. We empower our environment by working with indigenous Dacha as our primary reconstruction and development agent. We emphasize the fact that we need to work with what we have, which is indigenous land-raised cannabis, because only indigenous cannabis aligns with the National Development Plan by unlocking the economic prosperity of the country with an environmental bottom line as the foundation for economic and social policy that allows us to address economic and environmental security and the growing impact of climate change. So cannabis properly regulated and organized and managed to benefit the majority of our people will establish new pathways for rural development, placing a hugely viable cash crop in the hands of the rural poor, marginalized, and dispossessed. Cannabis is a South African natural resource and should therefore be managed in an innovative new social compact that recognizes the potential of this high value cash crop. I thank you for this opportunity to have made this presentation, and I invite as many questions as possible from the Portfolio Committee.
Thank you very much, sir. Thank you for sticking to the time given. I think everybody should follow your lead. Thank you very much. And thank you for the presentation. Members, the presentation is before you. I now invite questions or comments. I have Honorable Janji and Honorable Swart and Honorable Nevot Drahans in that order.
I think she was actually the first. Honorable Wilma was probably, her hand was up first, Chairperson.
Oh, okay. Honorable Nevot Drahans.
Chair to chair, Minister Swart, and we allow the chair to chair.
Your hand was last, Mr. Chianti.
Thank you. Thank you, Chair. Thank you for the presentation. I'd like to request that all the PowerPoint presentations